Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at an excellent book from Oxford University Press. It's on one of the favourite subjects, I think, of many students, many practitioners. It's a cornerstone of English law. It's the law of contract. This book is about contract formation. Now, I've taught contract law over the decades, and I always find this particular area, the formation of a contract, very interesting. This one is Contract Formation Law and Practice. It's in the second edition now, and it's been written by people who are well known to you, Michael Firmiston and G.J. Tolhurst, Greg Tolhurst. There's also a contribution from Eliza Mick as well, which I'll talk about in a few minutes. It's mentioned in the book, and I think that's important because we are moving forward with the law of contract in quite a big way at the moment, with the internet and all the other things that are changing within the fourth industrial revolution, and it's now upon us with digitisation. Now, Elizabeth and I gave the title for our book review this: perhaps the most litigated area of contract law, clearly explained and critically examined, and that of course is the formation of the contract in the first place. Did you or did you not have a contract? If you did, what was it? Remember, an awful lot of contracts we have are verbal, and that in itself causes a lot of problems. But if it's in writing, it's slightly different, of course. Now, we'll talk about the detail of this review in a minute. Let's have a look at the book first of all. Very much the house style of Oxford University Press. There's the front of it, there's a spine, and then there's nothing on the back. It's a hardback, dark royal blue colour, and what you've got is an index to start off with at the back, which is paragraph numbering. Not index, not page numbering, but paragraph numbering. And you can see immediately from that the structure. It's not a big index. You've got paragraph numbering at the sides, obviously, that's where you find the stuff, and you've got footnoting at the bottom. It's a lot of detail here. It's a very high quality publication. If you're looking for a first, this is something you could quote from in your examination answers. That's the preface setting out where we are at the moment with the book. Practical problems about contract formation continue to trouble lawyers, professionals and the courts. We talk about case law immediately. But you see, it's not something that's going to go away at all. There's a summary of the contents. You've got 14 chapters, then an index. Then you've got a detailed contents section all the way through there. Then you've got a table of cases, which is quite substantial, of course. All the usual suspects are there, I hasten to add. Then table of international treaties, and then you've got the EU legislation, and that will be with us for a while. Your Eurosceptics won't be pleased to hear, but there we go. Table of national legislation as well from different countries. And then you get into the main subject of the book itself, which is formation and the concept of agreement. What I do like is the short index for each chapter, which will give you some indication of, depending on what you're looking for, you should be able to find stuff pretty easily. It starts off, you've got the paragraph numbering at the sides, and then of course you can see a lot of footnoting all the way through. It's a very detailed book, a lot of information. You've got to have some reasonable understanding of contract law to read this book, but as I say, once you start getting into it, it's relatively straightforward. And one of the things I like about this work, clearly the prime work in the area is Chitting on Contracts, without any doubt, but I think this particular book adds greatly to some of the arguments and some of the debates which you've been having much more recently in the courts over the formation of a particular contract. That's what gives it its interest, and it's also something that might well be worth considering if you're a practitioner, because quite often you've got to look at the essence of the contract itself to realise exactly what the parties were intending to do, because there's some things that are clearly not contracts, such mere agreements. Then there are other things that are meant to be binding because they normally have a financial, clear financial obligation, and they also have other service obligations on people. So what do we say? What exactly is a contract? When is it not a contract? what is an offer and when is it not? Those are all the questions. And you can explain the possible subtleties of an invitation to treat, or can you? Always a problem. And the lovely words, an invitation to treat. Very Victorian, but lovely, lovely expression. As a practitioner, you will no doubt have the answers, or at least we would hope you would, because you are a practitioner and you will have qualified. But as this important new book from OUP reveals, said answers may loom as much more complex than you might have thought at the outset of a case. And I certainly do, every time I get one where I'm dealing with a breach of contract, and I've got one at the moment where it really is amazing what people will do. But I'm glad they do it, because that's where I get the work from. Now, as the authors, Michael Firmston and Greg Tolhurst, have warned, quote, practical problems about contract formation continue to trouble lawyers, professionals and the court. It's the start of it. Pressing home the point, they cite the example of a case where, on undisputed facts, the High Court, the Court of Appeal and the Supreme Court came up with 3 different answers, of which naturally all of which, of course, naturally have been incorporated in the text. Now you can see the points about the views that the different levels of court have. Now, for a law student, as well as the experienced practitioner, contract formation is obviously the first step and the first line of inquiry in the law of contract. Often regarded as the easiest, indeed the most entertaining aspect of contract law, contract formation, as the authors remind us, is perhaps the most litigated area of contract law, and that notably also the issue which occupies most of the court's time will be that of whether there's an agreement or not. And that, of course, is clearly what must be a factual matter right at the beginning. So the requirements of agreement therefore emerge as the main concern of this book, which scrutinises the topic of contract formation from the perspective of principle. And it's important to note that this is the second edition of what has become, in the 6 years since the first edition was published, the definitive work in what is a specific area of law, contract, as I say, the cornerstone of the common law, effectively. Particularly useful is the addition of the chapter on consideration, which I would say to overseas students who don't understand the concept of consideration, I think it's quite well explained here, because consideration is not the easiest concept, especially for persons from a different jurisdiction, because a little bit like the trust concept, we've created these devices and they're there for a reason. And you can see when you look at a case, the reason is it's about intention. It's always got to be about what did you really intend to do, hence consideration. It's to be considerate of the other side. Now, the rules governing the formation of contract law, say the authors, are easy to state, but they're difficult to apply, probably because typically lawyers are not brought in at the early stages of contract formation. Well, why should they be? Normally you just get on with it, but it's only when you have a knotty little problem to unravel you have to come to us. Although the book focuses on English law for English practitioners and discusses the leading English authorities, you will find that it also contains comparative case law, as the principles of contract formation are similar across many borders. And throughout the more than 450 pages of this title, the book covers a vast range of topics and issues pertaining to contract formation, from the concept of what is agreement, to offers and invitations to treat, to termination and revocation, to offers and to acceptance, and so forth. Also covered are online transactions, auctions and tenders, letters of intent, conditional contracts, and much more besides. And as I said, the contributor, Eliza Mick, has done a great deal on this new area, especially the online side, which I think is very helpful, because I've been doing cases recently where clearly the issue of the formation of a contract is dealt with by email, and there's nothing actually written down formally in handwriting, and it's all about what's been happening online. Now, let me conclude by saying this, that for practitioners in urgent need of advice and clarification on any number of matters relating to contract formation, The book is easy to navigate. As I said, it's nice to have the index at the front of each chapter, and you've got a relatively short but detailed index at the back. Also, you've got the detailed tables of contents, useful index, numbered paragraphs throughout, and the extensive footnoting, which I do think does help. Also, of course, there are tables of cases, European Union legislation, and our national legislation, plus a table of both the international treaties, the conventions, and other instruments. So what you've got here is an authoritative text that excels as a work of reference. Just the thing for embattled practitioners bemused by this surprisingly complex subject. But it's fun too. And you have to look at it that way, because you're actually looking about someone else's affairs. But at the same time, it's really interesting to see the way the parties behave and the way they've gone about their business. The publication date is cited at August 2016. Let's just have a little look at the book again. There's the front, and I just want to point out that the contributor, Eliza Mick, is mentioned there. Not actually on the front page, but on the front cover, but in the front page itself. And then there's a little information there as well. You just open the book up in the middle. I'm just going to go to the middle bit. Auctions and tenders are a favourite area, for examiners of course as well. There's a little index at the front, you've got the paragraph numbering, you've got footnoting, so you've got all of the house style very much associated with OUP. It's a lovely little book. I'd like to thank Michael and Greg very much indeed for producing it, and of course all the people at OUP. You make our lives a lot easier by producing this work, and in an era where many more people are much better informed and frankly more intelligent, because they've got better qualification, better access to information, this book helps the debate along nicely. And as I've said before right at the beginning, the law of contract is a cornerstone of English law, and this particular area is something you've got to get right, if you know what I mean, before you commence anything else with unravelling the contractual relationship of the parties. So thank you all very much indeed for producing another excellent book from OUP. Bye-bye.